Germany has adopted a law which obliges certain companies to conduct a human rights due diligence regarding their own activities and regarding their supply chains. In today's video, I will give an overview about this law. In June 2021, German Parliament has enacted a law which imposes an obligation to conduct human rights due diligence on certain companies. The name of the law is very long in German. It can be translated roughly as Act on Corporate Due Diligence Obligations for the Prevention of Human Rights Violations in Supply Chains. In today's video, I'm going to give a brief overview about this law. For the sake of brevity, I will refer to it as the Due Diligence Law or Supply Chain Due Diligence Act. First, a few words on the background. The activities of companies can have a major impact on the extent to which people enjoy their human rights. For this reason, there has long been a debate about whether obligations in the area of human rights should be imposed on companies. There are basically two opposing views on this. Some say that human rights are rights vis-à-vis the state, and that, as a consequence of this, securing human rights is a task of the state, not of companies. Many people who subscribe to this view say that it is of course good and desirable if companies stand up for human rights, but they say that this happens voluntarily. The other camp says what companies do has an impact on the enjoyment of human rights. Therefore, companies should also be held accountable for the consequences of their actions. Initially, the persons advocating in favor of voluntarism seemed to have the upper hand. In 2011, the United Nations adopted the Guiding Principles on Business and Human Rights. They are a set of principles regarding the impact of business activities on human rights. They state that states have an obligation to guarantee human rights and that companies have a responsibility to respect human rights. In other words, states have a legal obligation concerning human rights, but companies do not. Companies do have a responsibility, but this is not legally binding. In Germany, the government adopted the National Action Plan for Business and Human Rights in order to implement the UN Guiding Principles. This plan stipulated that companies should implement requirements and recommendations arising from the UN Guiding Principles in practice. However, it turned out that only a few companies actually did so. Therefore, the government decided to enact legislation to ensure that companies adhere to certain requirements in the area of human rights. There was a long discussion about what exactly the law should say. One point of discussion was whether companies should be liable for violations. That is, whether, for example, people whose human rights have been violated by a company's action should be able to claim damages. Another question was whether the law should include criminal provisions. In other words, should it be a criminal offense for members of corporate management if their company violates human rights? There were very different views on this, even within the government. Eventually, however, an agreement was reached, and in June 2021, the Supply Chain Due Diligence Act was passed. So what does the due diligence law say? Roughly speaking, the Act stipulates that companies are obliged to take certain measures to ensure that human rights are not violated in their supply chain. In addition, companies are subject to the same obligations with regard to certain environmental standards. However, this obligation does not apply to all companies, but only to companies that meet certain criteria. So the law basically sets out a number of obligations and it defines which companies must fulfill them. In addition to that, the law contains a chapter on how these obligations are enforced. So the first question that the law regulates is which companies it applies to. In other words, which companies are required to implement the due diligence obligation that the law talks about. The law will be introduced in 2 stages. It will enter into force on 1st of January 2023. From that point on, it will be initially applicable to companies that regularly employ 3,000 employees or more. As of January 2024, the scope of the number of companies to which the law applies will be expanded. From that date, the law will apply to all companies that regularly employ more than 1,000 employees. The law applies to companies that have their registered office in Germany. In addition, it also applies to foreign companies that have a branch office in Germany. When calculating the number of employees, only employees in Germany are counted. If, for example, a company has 800 employees in Germany and another 400 employees outside of Germany, then it does not fall within the scope of the law. Within the company, the employees within a group of companies are added. So if a company has 2,500 employees and 2 subsidiaries, each with another 500 employees, then it falls within the scope of the law. These are, roughly speaking, the companies to which the law applies. The next question is what due diligence obligations these companies have. There are basically 2 types of duties. Duties regarding human rights and duties regarding the environment. The law specifies certain human rights that it protects and certain environmental standards that it protects. In relation to these rights, the law imposes due diligence obligations on companies. Consequently, there are human rights due diligence obligations and environmental due diligence obligations. The human rights due diligence obligations state that a company must identify the risks of human rights violations in its supply chains, that it must take measures to prevent the risks from materializing, and that it must take remedial action if a violation has occurred. The environmental due diligence obligations basically say exactly the same, just in terms of the environment. Companies must take steps to identify the risks of violating the environmental standards that the law identifies. They must take steps to prevent the risks from materializing, and they must take remedial action when a violation has occurred. I would like to say 3 things about these duties in general. The first is, they are obligations of means, not of results. That means that companies have to make an effort to achieve these goals. But if that does not work, then that doesn't automatically constitute a breach of duty. So if there's a breach of human rights in a company's supply chain, that does not necessarily mean that the company has breached its duty of care. The idea behind this is that so many people are affected by companies' activities that it's not always possible to avoid every single violation. Also because suppliers of the company are involved and the company sometimes has only limited influence on companies in their supply chain. Nevertheless, these obligations are not just formalities or toothless tigers. Compliance with them is monitored by an authority. I'll say a little more about that in a moment. The second concerns the scope of the due diligence obligations. Companies are required to comply with due diligence obligations in their own business operations and with respect to their suppliers. This was also a point that was hotly contested in the debate on the law. The UN Guiding Principles on Business and Human Rights, which I mentioned earlier and on which the Due Diligence Act builds up, stipulate that companies bear responsibility for their entire supply chain. And in the discussion about the law, there were voices that wanted this to be implemented in the law in exactly the same way. And there were others who said, this goes too far. Companies can only be held responsible for what they do themselves, not what their suppliers do. The law as it stands now, or better, as it will stand once it enters into force, is the result of a political compromise. The due diligence obligations basically do not relate to the entire supply chain, but they're also not limited to the company's own business area. Rather, they relate to the company's own business and the first link in the supply chain. That means direct suppliers. However, the responsibility is extended if companies become aware that human rights or environmental standards are being violated elsewhere in the supply chain. If they can be aware of this, then these obligations are expanded to encompass also the link of the supply chain where the violation has occurred. The idea behind this is that it can be very difficult for companies to oversee their entire supply chain and check for violations. That is because large companies have tens of thousands of suppliers in some cases. But if a company knows that violations have occurred, then it is reasonable to expect them to take action. And the third point I would like to make is the extent of obligations companies have depends on what is adequate. This refers to the implementation of all obligations. For example, companies have to conduct a risk assessment. In this assessment, they must be adequate. Now, of course, you can argue about what is adequate in a given case. For example, what exactly a company has to do to conduct an adequate risk analysis. That is a point that is much criticized in connection with the law. There are very many terms in it that are very vague and that make it difficult to implement the law. However, this requirement also has its purpose. The companies to which the law applies are all large companies. So a company with 1,000 employees, that's quite something. But of course, there are big differences among those companies. There's a big difference between a company with 1,200 employees and Siemens or Volkswagen. That's why it makes sense, in principle, to distinguish between such companies in terms of obligations. On the other hand, it would be strange to demand the same efforts with regard to human rights from a medium-sized company and from Siemens. In this respect, the criterion makes sense. So what are the duties in detail? As I said, they are basically duties that relate to human rights and duties that relate to environmental standards. I will start with a few words on human rights. The law contains a catalogue of violations of human rights. Thus, specific rights are mentioned. The duty of companies relates to identifying the risk of violations of these rights, taking measures on this basis to prevent violations from occurring, and stopping violations if they already have occurred. The rights at stake are internationally recognized human rights set forth in international treaties. These treaties are listed in an annex to the law. I will not list all of these rights here. Some important ones are the prohibition of child labor, the prohibition of forced labor, the prohibition of slavery and practices similar to slavery, the freedom of association, and the prohibition of discrimination. The law takes a similar approach to obligations under environmental law. However, the rights mentioned here are significantly less extensive than in the area of human rights. Here, the main issues are certain forms of waste disposal and conventions on use of mercury. It is important for a company to determine internally the responsibility for implementing the Due Diligence Act. According to the law, this can be done, for example, by appointing a human rights officer. However, this is not a duty. What is important is that companies clearly define who is responsible for the implementation of the due diligence law. If a company fails to do so, that is an administrative offense that can be punished with significant fines. The persons appointed must report to the management at least once a year. It must be ensured that the information gets through to senior management. Then, companies must conduct a risk assessment. This means that they must identify the risks of violation of human rights, environmental standards in their own business area and at their direct suppliers. In other words, They need to get an overview of where they themselves are active, what they are doing, and what risks for human rights result from this. In addition, they must obtain an overview of their immediate suppliers and assess what risks to human rights result from their activities. They must then weigh and prioritize these risks. This means that they must assess which risks are particularly serious. On this basis, they must design preventive measures. That means they must consider what they can do to ensure that these risks do not materialize. For example, one preventive measure could be to conduct training courses to give employees a better sense of the human rights risks associated with their work. This can also affect employees of direct suppliers. Another example of preventive measures is contractual agreements. Companies agree with their immediate suppliers that they will guarantee certain standards in the area of human rights and the environment. And they also agree on ways to verify that they are adhered to. Companies are also required to take remedial action. If human rights violations occur in their own businesses or at a direct supplier, they must act. What exactly they must do depends on the individual case and also on what is possible for them. Again, more can be expected from a large international corporation than from a company with 4,000 employees. Also, because the possibilities for exerting influence are greater. For environmental risks, companies are subject to exactly the same obligations, only in relation to the environmental standards listed in the annex to the law. In addition, companies must introduce a complaints mechanism. In other words, they must create a way for victims of human rights violations to bring the violation to the attention of the company. These complaint mechanisms must meet certain requirements. Among other things, those affected must be able to submit their complaints anonymously. Finally, companies are still required to document their efforts and publicly report on them. This serves the purpose of transparency. Consumers and competitors should be able to find out exactly what companies are doing to meet their human rights obligations. However, monitoring does not only take place via the public. There is also regulatory oversight. The Federal Office of Economics and Export Control is the authority responsible for monitoring the due diligence law. Companies must submit their reports to that authority. It then checks whether the companies have fulfilled their obligations. The Federal Office of Economics and Export Control also has control options. It can, for example, request information from companies on how they are fulfilling their obligations or question witnesses. People whose human rights have been violated by the company's activities can report this to the Federal Office of Economics and Export Control. The office is then obliged to take action. The Due Diligence Act also contains provisions on fines. Substantial fines can be imposed on companies or on responsible persons for violations of the law. So, the law is not just a toothless tiger. That was my overview of the German due diligence law. I would be happy to receive suggestions, questions and comments on the video.